Hi. Two semi-related topics on my mind today. The first is my monthly rant. I got a rant about something. And so it's going to be about what's going on in the Wisconsin Supreme Court case regarding grandparent visitation. The case is Michels versus Lyons. And by the way, I never know quite how to cite that, if it's in Ray interest of the initials or whatever, but I'm going to call it Michels versus Lyons. It's 2017 AP 1142 if you want to look it up. Just to refresh everyone's recollection, it is the first family law case before our Supreme Court in, 6 or 7 years since McCreath, which was the case on professional goodwill, the orthodontist case. And since McCreath, the Wisconsin Supreme Court has not decided a single case in this field, part of it because there aren't a lot of them that are being appealed, and of those who are being appealed, not that seek review. And this grandparent visitation case is not only the first case, but it's an important one, and it involves a very important issue. I'm going to be writing about it in flu and also in some other areas that I'll talk to you about in a minute. But the rant I have is the fact that in checking the Court of Appeals CCAP entries on it, there are 5 organizations which have filed amicus briefs in the case. Among them are not the family law section of the State Bar of Wisconsin or the Wisconsin chapter of the AAML. And I'm a little disappointed in both. In terms of the family law section of the State Bar, I'm liaison to it from the Board of Governors of the State Bar, and brought up the topic at the last meeting, and I said I would assist in an amicus brief, but I'm not going to write it myself. I've sort of been there, done that. I've written an amicus brief on behalf of the State Bar of Wisconsin, and it's a lot of work, but I would assist someone, and nobody was interested in following up on it, and apparently the leadership didn't think it was important. And same thing with the AAML, which I suggested that the Wisconsin chapter might want to write an amicus brief, and nobody seemed to be real interested in. Maybe nobody's got the time to work. Maybe nobody wanted to work with me on it. That's also possible. But it's important because of not only the fact this is the first Wisconsin family law case, and as I said, at least 5 years before our Supreme Court, but it involves a very, very important issue regarding grandparent visitation. As a grandparent, of course, it's critically important to me in terms of its effect, but moreover and more important regarding its effect on children. And the case that is discussed a lot in the briefs and in the amicus briefs is, of course, Troxel versus Granville, the U.S. Supreme Court case dealing with third-party visitation. And Michels presents the issue of what's the burden of proof of grandparents seeking to have visitation with children. Is it clear and convincing evidence, or is it a preponderance to overcome the constitutional presumption in Troxel that fit parents have the right to make their own decisions regarding children? It's a really, really important issue, and it's important not just for grandparents, but more importantly for children, because it's my belief, my theory, my philosophy as well, that the legal system, while necessary to protect children in abuse and neglect cases in the family law field, serves better uses by not involving children in litigation and trying to resolve and settle cases, which is why mediation is so important and so valuable in this field. And allowing grandparents ready and easy access into cases, I feel, is a major danger area for children, and encouraging litigation and fighting over children. So grandparent visitation involves weighing of different rights and interests. The rights and interests of grandparents on the one hand, who can do wonderful things for children, both in terms of nurturing and financially, and the rights and interests of children. And my theory and philosophy is that children's interests ought to be paramount where there's a conflict. And it's important because the There's rarely groups and organizations whose interest is based upon children. We got fathers' rights groups out there. We have groups that are interested in women's rights. There are a few groups that are interested in terms of just the rights of the children. I would have hoped that the family law section of the State Bar and the AAML would have weighed in on it, but they didn't. But that brings me to my second topic, which is I don't think it's fair or right for me to say that other groups should weigh in on this important issue if I'm not willing to weigh in on my own. And I would like to be able to express my opinions, especially in terms of how I think it affects children in more than just this video, which I don't know how many people see it, but probably not as many as I would like. For the last 3-4 years, I've written a bi-monthly, every other month, right, column for the family, not for the family law section, but the State Bar of Wisconsin, and its Inside Track column that it's an email service that the State Bar sends out once a month. And I'm going to continue to do that. But the problem with writing for the State Bar of Wisconsin is they have to be careful of what positions they take, and they have to do that for two very legitimate reasons, one of which is that they are a creation of the Wisconsin Supreme Court. They're not an arm of the Supreme Court, but they are regulated by the Supreme Court. They're created by Supreme Court rule, and therefore they have to be cautious of how far they go in terms of criticizing what the Supreme Court is doing. It's not only because they're a creation, but it's also good politics. Hopefully the ultimate decision of Michels is one which will not require a lot of criticism, but in the event it does, I'd like to be able to say what I think about it rather than have to be restricted by political considerations. And the second reason that the State Bar is cautious, and rightfully so, is if both sides are represented by lawyers who therefore have to be members of the State Bar, they want to be careful that they're not offending one of their members, especially in a mandatory membership organization where if somebody's offended, they can't vote with their feet. You can't just quit the State Bar and keep practicing law. So as a result, the State Bar is careful in terms of what appears in their publications, how far they go criticizing something that a court does, and how far it takes a position affecting its members, all of which is fair game. But it frustrates me a bit because I got a lot of opinions. They may not be right, but they're my opinions, and I'd like to express them a little more forcefully, especially when it comes to issues affecting the children that I think are quite important. So for many, many years, actually, more than I can remember, I wrote a periodic column for the Wisconsin Law Journal, and I stopped doing it when my editor stopped working for them and took a full-time job practicing law. Jane, I miss you. But recently reached an agreement with the Wisconsin Law Journal to begin writing for them again. They'll assign a new editor to me, and hopefully that'll help with my grammar and punctuation and other mistakes that all of us lawyers who write stuff realize we're not that good at. But it'll allow me more free range in terms of expressing opinions. And so if you're not a subscriber to the Wisconsin Law Journal, hey, subscribe. You'll like it, okay? It's got a lot of good information, a lot of good things in it. And then at least every other month, maybe more often if something comes to my mind, I'll be writing an article on topics that I think are of interest to practitioners of family law, for that matter, anybody with an interest in this field. So speaking of which, you can expect to see an article coming up fairly soon on Michels and what my feelings are and what the Supreme Court should do about the case. Of course, when the decision comes down, I'll write another article, good, bad, or indifferent, about how I feel about it. And finally, if there's an issue out there that anyone listening to this video thinks is important, something they'd like to see me write about, shoot me an email, gherman@loebherman.com. I may decide that it's not something I'm interested in writing about, but if you see an area now and in the future that you think requires some editorial comment, prefer things that are a little more controversial, a little more edgy than just, hey, wouldn't it be nice if children are treated fairly, and of course we're unbiased and all that, and nobody needs that. Something a little more interesting, a little more edgy, a little more exciting. Shoot me an email. I'd be interested in ideas and thoughts. And also, when you read my columns, when they start appearing in the next month or so, I hope that any comments, even criticisms, gentle criticisms, please, of it, and suggestions and ideas are always welcome.